Okay, I thought I'd read to you my submission to the High Court, the Administrative Court branch of the High Court. I believe it's quite a professionally compiled piece. I've already, the main 2-3 appendices, one containing the submission of Julian Assange, Appendix 3, and an appendix of the UN Working Group on Arbitrary Detention's judgment at Appendix 4, and also an affidavit of Julian Assange of Appendix 5 is the principal grounds which I make the application on. I'm standing, in essence, on a UN judgment based upon an application by Julian Assange. So it should, regardless of my calibre, be quite a substantial case, you might think. Quite a powerful case. This is one of the cited evidences of Julian Assange of his persecution, and the persecution he legitimately fears in the US. These are some quotes that I like. Okay, I've been at High Court a couple of times before, and there's clearly a curiosity about who I am, and so it's almost, it shouldn't be so, that there shouldn't be a prejudice about who I am, where I come from, my academic background, but this burning curiosity that I've encountered, I feel it's best to rather than tell the judiciary that it's highly prejudicial to even inquire. It's better to get it stated and over and done with. As I detailed in a recent submission reading by the UK government, one of the principal ways the government will try to impede my bringing this case is over the issue of standing. So I begin the case by meeting that question. Whether I do successfully or not will shortly be determined at appeal court. But what I would say is, it's quite interesting to note that today, and recently in the news, is a certain lady who has brought now 2 cases to the Supreme Court, and I would claim her what we call standing and of public interest in this Julian Assange case. I will ask the appeal court that if I don't, that the standing I claim in this case, my connection to the case is the same level of of legal connection as Mrs. Gina Miller claims in her recent victories over the government at the Supreme Court. That is, holding the government to account over wrongdoing. Moreover, in this case, I'm holding the government to account over its being in the business of arbitrary detention. So I begin paragraph 1. The appellant brings this case specifically on grounds of public interest. The appellant brings this case as a citizen with the gravest concerns over matters having an extremely serious public interest. The charge brought against the government by the appellant, and with strong reliance upon the submissions of Julian Assange to the United Nations Working Group on Arbitrary Detention, and the subsequent opinion of that most high of tribunals, is that the UK government is guilty of the arbitrary detention of Julian Assange. The court must take what is the modern approach to judicial review as expressed by Lord Diplock in Regina versus Inland Revenue Commissioners. It would, in my view, be a grave lacuna in our system of public law if a pressure group like the Federation, or even a single public-spirited taxpayer, were prevented by outdated technical rules of locus standi from bringing the matter to attention to the court to vindicate the rule of law and to get the unlawful conduct stopped. Now, the government says, I have no understanding of public interest cases, I have no understanding of public interest, of public law. I don't know whether I quote it later. I certainly, this case, which will be central to establishing my standing, I enclose in completeness in my submission to the appeal court. In that fuller submission, it is later said by Lord Diplock, or one of the other lords possibly, but I'm pretty sure it's Lord Diplock, that it's the point is to get wrongdoing stopped. And so it is with Gina Miller, to get the government, the proroguing of Parliament stopped. Yeah, it's wrongdoing by the government. Anybody can bring such a case when it is of general implication. I honestly don't believe, I think, see, the government has not sought to engage with Julian Assange's submission or the UN's decision at all. Yeah, they're trying to shoot the wings off this bird before it gets flying, understandably, because the government is in the wrong. Paragraph 3. The UK government imprisons Julian Assange contrary to the constitutional principle of the rule of law as enacted by Parliament in the Constitutional Reform Act 2005. The government has specifically failed in this regard in respect of Lord Bingham's conception of the rule of law, and as echoed by Attorney General Dominic Grieve. The manner of these failings are briefly given as 1. A failure to adhere to international law and norms. 2. Failure in the respect of human rights. 3. Acting with an arbitrary discretion. Paragraph 4. Acting with an arbitrary discretion. The UN Working Group on Arbitrary Detention has determined that Julian Assange is arbitrarily detained. It is reported that the Inter-American Court of Human Rights has made similar determinations. Arbitrariness is often a misunderstood concept in the context of justice. Most often, arbitrariness carries a strong connotation of randomness in the public domain, usually to the degree of synonymity. It is this sense of the word which many let dominate over other contextual situations. In many cases, when it is brought to a person's attention that they are trying to stand on an arbitrary argument or factor, they become offended. Paragraph 6. Typically and most generally, arbitrariness other than in the random sense, involves acknowledging the conscious choosing by free agents or actors. However, Harvard's Professor Michael Sandel, in his Justice series on political philosophy, subtitled What's the Right Thing to Do, often refers to arbitrariness and arbitrary factors from a moral point of view. This begs the question, if arbitrariness has points of view, how many different or relevant points of view are there in regards of arbitrariness? What does it even mean to be basing something on arbitrary factors from a moral point of view? When and how do these factors in one setting get called arbitrary and in another not? And further, what is the point of view or the standpoint that law and justice take with respect to arbitrariness? The appellant finds 4 readily identifiable points of view to arbitrariness. First, as stated in Michael Sandel's arbitrariness from a moral point of view. Second is arbitrariness from a point of view of purpose or towards a particular end. Third is arbitrarily deviating from a normal procedure format. And finally, there is arbitrary infringement of liberty. The UK government officials and most commentators, if they care to engage with the notion of arbitrariness in the Julian Assange case at all, are wrongly transfixed upon arbitrariness from the procedural point of view. This is an important concept, but it is the arbitrariness in the interference with liberty that has come to be understood as the driving purpose behind the conception of human rights. This error is none more so clearly stated than in the Guardian editorial piece, which claims arbitrary detention means that due legal process has not been observed. It has. It can be noted a fairly implemented notion of due process is implied by guaranteeing a principle in which society is free from arbitrary governmental interference in the sense of restricting liberty within the bounds of necessity. It does not, however, work the other way around. Having a robust and equally applied procedure does not guarantee that we have an unnecessary and non-arbitrary interference with liberty. To reason and puzzle of the UN WGAD decision on the basis that Julian Assange has been through the UK legal system is to commit the formal fallacy of affirming the consequence. A simple example of which is in considering the true claim, if it's raining, then the streets are wet. We go on wrongly to think we can infer, because the streets are wet, we can be sure it's raining. I'll omit the discussion where I try and prove this point about contingent implications, and go on to paragraph 14. The conception of human rights is a matter of logic and a fundamental starting point for modern political philosophy. It is a starting point with a purpose to use reason to extricate ourselves from what philosopher Thomas Hobbes referred to as a state of nature and the logic of anarchy. The endeavour of reason generates one further intrinsic purpose, and that is the notion that rights cannot be so encompassing as to defeat the purpose to which we invoke them. Such an idea would quite correctly be referred to as self-detonating or self-defeating. It is a demand of reason and a fundamental prerequisite of its formulation in mathematics that we have the law of non-contradiction. We have then the need for self-consistency, the restriction upon purposes and by extension rights, such that rights are restricted by necessity within a democracy. The United Nations Universal Declaration of Human Rights preamble very much echoes the above logic and motivations in its aspirations and recognition of, quote, the inherent dignity and the equality and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. The preamble also gives us important confirmation of the international dimension over which the conception of human rights must play. In the aftermath of World War II, the Declaration understands that it is the denial of the logic of human rights that has led to, quote, barbarous acts that have outraged the conscience of mankind, and how man should not be left with violence as the only recourse, quote, as the last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Paragraph 17. Towards the end of the UN Declaration of Human Rights preamble, we have the insistence that states have pledged themselves to achieve, in cooperation with the United Nations, the promotion of universal respect for and observance of human rights and fundamental freedoms. The UK government has failed to both cooperate with the United Nations Working Group on Arbitrary Detention and seriously engage with their conclusions. Further, in failing to engage with the Working Group on Arbitrary Detention, the UK government has acted arbitrarily in not doing so. This has led them to arbitrarily disconcern themselves with the complex issues of asylum and the issue of refoulement in particular. These references to foundations of freedom and fundamental freedoms are not to be taken as lofty abstract goals of which we can pragmatically and arbitrarily dismiss at our choosing. In Golder versus UK, we are taught that the great value of the preamble to a legal instrument in ascertaining its goals and purposes. The preamble then shines a light upon the very definition of arbitrariness. From a purposive reading of the Universal Declaration of Human Rights, the meaning of arbitrariness as pertains to justice can be seen to be the most demanding one given above by the appellant, that being arbitrariness to liberty. That is, the correct legal connotation and contextual understanding of arbitrariness stem from arbitrary aspirations to protect liberty. There is then no foundation to narrow interpretations to the UDHR, the Universal Declaration of Human Rights, and its demands for non-arbitrariness as simply having the limited meaning of a demand for a rigorous procedure. There simply is no justification to exclude factors which point to the arbitrary and unnecessary infringements of liberty. Every time it is found necessary to declare an incompatibility with a particular human right, it is understood that this is an arbitrary deviation from a principle enshrined therein. In these circumstances, we have individuals who choose on a formulation of law or the Constitution of some procedure that challenges either directly or indirectly some liberty that is of fundamental importance. Here I talk about the need for a broad, purposive reading of the Article 8 right to private life, often misunderstood as the limited article of right to privacy, as in the right to be away from prying eyes almost. Paragraph 20. The legal encoding of the preamble's most general aspirations can then be seen constructed in Article 8 of the European Convention on Human Rights and the Human Rights Act 1998, HRA. In this article, though it is necessarily qualified, we have the right to a private life as a concept of a private citizen separate from state. This article is often superficially read and thought of as simply the article that grants the general need for privacy from prying eyes. The power and generality of Article 8 is admittedly not self-evident, but is born of the direction pointed to by the preamble of the UN Declaration of Human Rights and the subsequent hard work interpreting the words in accordance with law. The text of Article 8 reads as follows. I'll spare you the reading of the text. Paragraph 23. On superficial reading, it would be easy to see this article as imbuing the concept of lawfulness only with a requirement of some bureaucratic process which must not be deviated from. This would be great folly. In Linguistics vs. Belgium, we have the essential object of Article 8 referenced as being one of protecting the individual against arbitrary interference by public authorities in his private family life. The judgment goes further to link, which is only understandable in the sense of arbitrariness from the liberty point of view, the concept of arbitrariness and discrimination. That is, at its essence, discrimination is always the arbitrary interference and deprivation of liberty based on factors that are incompatible with the Universal Declaration's preamble. The specific phrase "in accordance with law." In the case of Sunday Times versus UK, a technical issue is addressed and cleared up, explaining that by a quirk of translation, the term "in accordance with law" needs to be reconciled as having the same meaning as the words "as prescribed by law." That's the two phrases are used in different articles in the Human Rights Act, but it's just a quirk of translation. It just clearly establishes that they're the same. This nuance aside, the meaning of "in accordance with law" can be found in paragraph 49 to entail that law must be accessible to the citizen, that law should be formulated with precision. The importance of precision being in a citizen's reasonable need to foresee the consequences of his actions might entail, concerned here in the principle of predictability. Apart from this being almost an educational piece on human rights, it's been a development as the current political context develops. The US legal scholar, Horowitz, I think his name is, in a video caption talking about the Assange case, explicitly explains that there is no predictability of the Supreme Court's judgment. By the time, say, 2 years have elapsed and Julian Assange is potentially extradited to the US, judges will have been retired and political appointments could be made wherein the protection of the US Constitution's First Amendment and the protection of the freedom of speech and journalism may well be significantly undermined to allow a prosecution of Julian Assange that might not otherwise have been. So paragraph 27, in the case of Marx v Belgium, the essential character of protecting a citizen from arbitrary interference is again reiterated. In the case of Silva and others, we see the beginnings of the most succinct and comprehensive interpretation which decrees for the interference to be in accordance with law, that it must be, have a basis in law, be accessible and be precise. But it goes on and it notes, a law which confers a discretion must indicate the scope of that discretion. In Malone v UK, we see that Article 8 is concerned with the broad purpose of scrutinising the quality of law and its compliance with the rule of law, which by Lord Bingham's opinion would mean the constraint of discretion to prevent the possibility of any encroachment of arbitrariness. Further, by the phrase sufficient clarity, having regard to legitimate aim of the measure in question to give the individual adequate protection against arbitrary interference. We have the emergence, tied to this article, the notion of purposes or ends and how they can be subject to arbitrariness. The concept is an indirect formulation and attachment of the principle of proportionality, which is now established in human rights law. The action of purpose in relation to arbitrariness is contextually dictated by the Universal Declaration preamble and its dedication to liberty and freedoms. In Reykjavik v Hungary, the concept of lawful and lawfulness are united with the concept of what it means to be in accordance with law, that is generally an absence of arbitrariness. What are you doing, eh? What are you doing? All right. Go on, get down. In Petty versus UK, the full philosophical import and nobler goals of Article 8 are brought out when it is stated that Article 8 is expressed in terms directed to the protection of personal autonomy while individuals are living their lives. This recognition of autonomy is direct enshrinement of the laudable purposes of the Universal Declaration preamble towards liberty, freedom and in general self-determination free from arbitrary interference. In the case of Gillan and Quinton v UK, it is understood that public power is in need of scrutiny, with the need of constraints upon arbitrariness, ensuring such powers can never become unfettered in the manner in which they interfere with a citizen's private life. unfettered power being expressly stated as contrary to the rule of law. In Ternovsky versus Hungary, we have it explicitly stated that the lawfulness is to be in accordance with law, and that the private life is a broad term encompassing inter alia aspects of an individual's physical and social identity, including the right of personal autonomy. In summary then, if Article 8 has relevance to all interference with citizens and does so placing a need for respect of autonomy and absence of arbitrariness, then it is clear that these standards will permeate all law or procedural rules as they may find themselves acting on individuals. This is a monumental insight in which the necessity of formulating clearly those laws or procedures and of having them not arbitrarily deviated from, in the procedural sense, instrumentally serves the higher aim of protecting freedoms from arbitrary interference. It is only through the higher sense of arbitrariness, as it detracts from liberty, that sense can be made of what it means to be not acting in a compatible way with other articles of the European Convention on Human Rights, or indeed the notion of proportionality. The universality of Article 8 lends itself to the conclusion that in essence there is only need for Article 8. Any derogation of responsibilities in regards of any other human right will necessarily be able to be formulated as a breach of Article 8 also. The principle of proportionality. The principle of proportionality is well established in our law, as Lord Sumption said in Bank Mellot v. Her Majesty's Treasurer. The question depends on an exacting analysis of the factual case advanced in defence of the measure, in order to determine whether 1. Its objective is sufficiently important to justify the limitation of the fundamental right, and 2. Whether it is rationally connected with that objective. 3. Whether a less intrusive measure could have been used. 4. Whether, having regard to these matters, the severity of the consequences, a fair balance being struck between the right of the individual and the interests of the community. All right, you two. The more nuanced point here in respect of proportionality is in the comprehension that if a measure of 5 justice units, the more nuanced point here in respect of proportionality is in the comprehension that if a measure of 5 justice units is required to deliver a particular outcome in regards of some hypothetical offence, and then you deliver 8 justice units, you have then unquestionably acted arbitrarily. It does not matter if the procedure or the law demands the issuance of 8 justice units. The fact that an additional 3 units has been delivered cannot be rationally argued without subjectivity and arbitrariness. The relevant question brings out the character of the arbitrary judgment being, why not 4 or 5 or 25 additional units? Thus, when a disproportionate response or a response that leads to a disproportionate outcome can always be seen to be either arbitrary to the purpose, in the degree to which it goes beyond that which is necessary in measure. Arbitrariness in the procedure, and by extension arbitrary to the purpose, almost always certainly then leads to a disproportionality in treatment. Born of this arbitrariness is the excuse given by many a wrongdoer's claim that they were only following orders. Lastly, on the issue of proportionality, it is a natural corollary that any measure of action that is set in place with an indefinite expiration date will also always be disproportionate by the elapse of time. Any procedure that lacks a suitable judicial review of such actions or events that might lead to detention necessarily lead to uncertainty and a lack of predictability. Thus, such actions, events and procedures cannot be said to be in accordance with law as the demands of Article. The complexity of the Julian Assange case. The determination of detention in the Julian Assange case is a complex matter in which lack of bars, locked security doors or allusions to volitional elements cannot be superficially argued. The legal understanding is that the rational and full weighing of the intensity and degree in which the totality of any loss of liberty must be understood. No matter what the nature or substance involved in the loss of liberty, liberty is always valuable and a fundamental right to be well respected. The standard accepted doctrine is that a whole range of criteria must be assessed, including, but not limited to, duration, effects, and the manner in which liberty is lost. The determination of detention in Assange's case has lots of additional complexity which cannot be met with superficial dismissive assertions such as he merely wants to evade Swiss justice, as in the allusions given by the UK Foreign Secretaries Philip Hammond and Jeremy Hunt. Assange, like everybody, is to be presumed innocent until found guilty. From the moment Assange walked into the Ecuadorian embassy, it is apparent to the world his claims require a lot more depth and analysis than the UK government has allowed for. The fact that the UK government has refused to consider the complexities is the government's most pervasive arbitrary act. Julian Assange is entitled to remedy under human rights law and entitled to have his claims met with serious engagement under the mandates of Article 8. Julian Assange's position has been described as one of legal limbo. The active UK arrest warrant over an investigative matter that has been formally dropped, when understood in its contributory role to the Assange limbo or vicious cycle, then, under human rights law and the concomitant principles of proportionality and refrainment from arbitrariness, it must be understood that this arrest warrant has failed to be reviewed with regards to its purposes and effects. The failure results directly and necessarily in the warrant becoming unlawful itself over a protracted period of time, as is the case with the specific circumstances of the Assange case. This is a prima facie truth, absent any suitable review of such a warrant. Assange has applied to Ecuador for asylum. This is an international norm and right afforded to citizens of the world. On the basis, Ecuador give long and serious consideration to Assange's application and ultimately granted him political asylum. The UK itself grants many tens of thousands each year asylum based upon the same internationally agreed principles. Both the UK and the US have famously participated in this normal practice, giving rise to a reasonable expectation that this right should be respected in the case of Assange. This being the case, there are international laws, treaties and norms that place a responsibility above and beyond the UK's existing arrest warrant to allow and positively see to it that Assange has chance to enjoy this status. The UK also is commanded in its responsibility to consider and give safeguard and respect to any risk of refoulement to a nation state that might present a risk to Assange in the form of other human rights violations. To negate the concept or not to subscribe to the concept of the principle of non-refoulement is to challenge and undermine the very concept of asylum. Does the UK subscribe to the principle of granting asylum? The UK law is bound by the principles of upholding asylum and asylum claims. Legitimate and legal asylum claims in the case of Assange are an unpalatable truth for the UK government, as it steadfastly refuses to admit its complexity into their arguments. This apparent resolve is arbitrary and prohibited under Article 8 and discriminatory under Article 14. It is absolutely necessary and a legal demand and responsibility placed upon the UK government to apply arguments of depth that meet this added dimension of complexity. Failure to meet the depths of the Assange arguments renders the UK government's statements and arguments largely irrelevant. In irrelevancy, we have a lack of serious purpose in the UK government's engagement that appears happy with the status quo and legal limbo of Julian Assange. This is then, by extension, disproportionate treatment of Assange, which requires a purposeful look at his case. Assange has such legitimate concerns about refoulement to the United States of America, wherein the death penalty has not been abolished and torturous methodologies are used upon prisoners. Moreover, there is clearly an atmosphere of political persecution that means he could not receive a fair trial. It has been found to be a matter of reason logic that to subscribe to the very principle of asylum is also to be bound to consider the issue of refoulement. This logic can be understood to flow from Erie versus Ireland, wherein rights are to be given concrete and real effect and not to exist as an abstract, intangible, illusory thing, arbitrary no matter when it occurred. The UK arrest warrant needs to be understood in the context of arbitrary and disproportionate European arrest warrant. The legal conditions at the time of granting an extradition order pursuant to this warrant have changed. The conditions now in operation are very much a consequence of a review of the apparent then arbitrary and disproportionate features which the high-profile Julian Assange case raised. This change in the law is recognition that there was a need for change. It is clear that an extradition order would not have been issued against Julian Assange had his case been evaluated under the newer, fairer and proportionate considerations of the altered law. Furthermore, since this extradition warrant is causal in subsequent to seeking of political asylum by Assange, based upon legitimate fears, as determined by the Ecuadorian government, this injustice is very much causal in the current stagnant and ineffective arrest warrant that is effectively detaining him. The Antisocial Behaviour Crime and Policing Act 2014, introduced by way of amending the Extradition Act, inserted clear mandates to prevent disproportionate requests for extradition. This is done by the insertion of Section 12A, preventing extradition for simple investigatory purposes. Furthermore, in addition to the human rights considerations of Section 21, inserted now is a specific emphasis of the need to consider proportionality with Section 21A. The UK government must give Julian Assange the benefit of this UK legal change under the auspices of the previously mentioned case Ure versus Ireland, in which protection of rights must be given practical effect. It is arbitrary to negate a fundamental right based upon temporal ordering. It is understood with good reason that offences not be retrospectively prosecuted with regards to new laws for the human rights considerations already given. It is clear that when it comes to persons suffering under arbitrary and disproportionate treatment under one procedural regime, and that regime is changed in material ways that shed light on his arbitrary disproportionate treatment under the former regime, then there is no rational reason or purpose for the continuance of that treatment. A person who suffered under a prior regime must be legitimately entitled to remedy. It is entirely arbitrary from the human rights point of view to not give those affected the benefits of changed legislation. From the moment there are legal changes that have real possibility of conferring benefit in regards of fundamental human rights, and those benefits are not conferred, this constitutes an additional arbitrary action that a person is subjected to. Again, temporal ordering is not an arbitrary factor from a justice. Is an arbitrary factor from a human rights rule of law point of view. I'll say it again. Again, temporal ordering is an arbitrary factor from a justice, human rights or rule of law point of view. As part of this reasoning, it is not to be overlooked, even though fears of personal safety ought to, and legally do, trump simple allegations involved in a preliminary investigation. The Swedish case itself, which led to the European arrest warrant, is very much procedurally flawed and replete with arbitrariness and disproportionality. This is a complex issue which will not be detailed here, but it suffices to say that Julian Assange has offered to cooperate with Swedish authorities on terms that respect his safety. For the longest while, Swedish authorities bluntly, arbitrarily and disproportionately dismissed any chance of this. The final point of consideration being that the investigation has terminated and presumably the European arrest warrant terminated, rendering both UK arrest warrant and extradition under current without any overriding purpose. Julian Assange has reasonable expectations to be in command of a right to seek and then actively afforded the benefit of political asylum for the reasons previously discussed. The character of this right is so far-reaching that it places an active duty on the UK to arrange safe passage of Assange to Ecuador. These rights arise from international law and norms in the necessity of giving effect to such rights. Pervading all these issues and concerns in the Julian Assange case is the risk of refoulement to the US that the UK is also under obligation to respect. The UK government and legal institutions so far have given blithely regard so far as the complexity of the Assange case. These superficial rebuffs and facile engagements constitute arbitrary derogation from their responsibilities, not to be dismissive of complexity. The resulting arbitrary and disproportionate actions, then, of the UK prima facie constitute a breach of Human Rights Act 1998 Article 8, which demands no treatment of individuals be undertaken in such a manner. There is a long history of case law specifically explicating how, in relation to Article 8, arbitrariness, autonomy, regulation, discretion and prevention of unfettered powers must be safeguarded. The consequence of this arbitrary treatment is then readily seen to be an infringement on Julian Assange's human rights given by articles. Prohibition of torture. Arbitrary actions that lead to confinement, isolation, lack of medical access, constant surveillance, lack of exercise, lack of fresh air are all in breach of internationally recognised and regarded minimum standard rules for treatment of prisoners over a protracted and indeterminate period can surely be understood as amounting to degrading treatment which ignores the inherent dignity of Julian Assange. Right to liberty and security. Arbitrary actions that lead to the lack of needed medical treatment necessarily render a person to be without security in his personhood. Undoubtedly, arbitrary actions that lead to loss of liberty in law, it is now understood, are certain to lead to the status of arbitrary detention, when those measures, in the manner of their occurrence, are unduly arbitrary, unduly harsh, or disproportionate. Right to a fair trial. Arbitrary actions over a prolonged period of time with determined politicising of his case have unquestionably given grave doubts over whether Julian Assange can receive a fair trial in regards of matters in Sweden or the United States. Continuing on the nature of arbitrariness. In a House Judiciary Committee hearing, Judge John Conyers can be seen enunciating and admitting to the necessary considerations of many of the complexities of Julian Assange. It is insightful to see a young man embarking upon studies at a Harvard Michael Sandel philosophy course available on YouTube, to see him discover in a moment of insight that which is known anathema to legal principles, that is, that arbitrarily privileging of self over others is really the basis of all crime. Professor Sandel himself articulating that this very arbitrary nature of free autonomous persons choosing their own conceptions of the good life that has brought about modern political philosophy to understand the necessity of a system based on fundamental rights. The net consequences of the inextricable arbitrariness and discrimination is evident and result in unlawful breach of Article 14. All these factors then amount to arbitrary detention which is unlawful and in a condition such that, as stated and realised by Article 3, 5, 6, 7, 10, 11, 12, 14, 17 and 18 are also infringed. Such is the universal detrimental character of arbitrary detention. The force of rule of law and the international dimension. Julian Assange can be considered arbitrarily detained contrary to the constitutional principle of the rule of law in many of its facets, and particularly in its international obligations. The Honourable and late Lord Bingham tells us arbitrariness is a central anathema to the rule of law, and that international obligations and international law play a key role in the existence of the constitutional concept of the rule of law. Lord Bingham's opinion and the point of view is directly echoed in conservative Attorney General Dominic Grieve's statement on the rule of law. This statement includes the importance of the absence of arbitrariness through law and not discretion, and includes the need to respect international law. All complexities taken into account, Julian Assange, it appears to the appellant, Julian Assange has been arbitrarily and disproportionately treated, and this in turn has led to human rights violations under Article 3, and I go through them. A summary of arbitrary and disproportionate treatment that exists separately and also under is listed. I go on to explain Assange cannot be extradited to Sweden or the United States of America. The US has removed itself from the Human Rights Council and cannot be regarded as a nation that will safeguard human rights of individuals. The US has announced its disregard the relatively recent nuclear treaty with Iran, with strong opposition from most of Europe. The US has announced it has pulled out of the historic medium-range nuclear arms treaty that it made with Russia. The US tortures prisoners and also renditions them off to off land to escape its own legal obligations. The US has tortured US prisoners Chelsea Manning, then Bradley. The US instigated an illegal war on Iraq. This shows in the many legal submissions. This is shown in the many legal submissions to the Iraq inquiry, which were invited but not to be part of the Chilcot report. Julian Assange has been scapegoated and vilified by many recognisable US public and political figures. Examples of these are cited in his submission to the working group and further evidenced by Thomas Blanton in the House Judiciary Committee hearing of 10th of December 2010. His journalistic organisation has had banking facilities removed from it by pure arbitrary political pressure without any legal basis that could form any notion of interference as prescribed by law. All of the above indicates that the US does not adhere to the rule of law as it is conceived with the international dimension and as it is conceived free from arbitrary discretion. The exemption from the international rule of law is often termed quite correctly and insightfully US exceptionalism. This means any guarantees that the US given by the US in regards of any potential future treatment of Assange can carry little to no weight. Julian Assange cannot receive a fair trial in the US due to a decade of political persecution for the embarrassing publications the organisation WikiLeaks that he has founded has made. Similarly, Julian Assange cannot receive a fair trial in Sweden because of a near decade's worth of bad publicity, in which whenever his name is mentioned, it is virtually always accompanied with unfairly represented and highly prejudicial of accusations, and very often insinuated that his imprisonment in the Ecuador is simply an attempt to escape injustice. Taking all the above into account, it is difficult to imagine how the US can give any credible or adequate written assurances as demanded in government guidance on extradition. Worryingly, this discretion as to what shall count as adequate appears to be an unfettered discretion contrary to the rule of law and contrary to Article 8. The consequences of this arbitrary interference leading, in the case of Julian Assange, to a legitimate worry about great many contraventions that would follow. What is an investigative journalism? What is investigative journalism? or the reporting on whistleblowers for whom the dictates of conscience mean they must break the rules. If not recognition of the need of a process and an environment in which individuals can exercise their conscience and give vital information to the public. It is a trust in the conscience on the empowerment of individuals in the way that cannot be entrusted to formal or institutional power, and an understanding that law can help conceal, that laws can help conceal pernicious acts through secrecy. This is recognised in English common law as concerns the most general rule on the admissibility of evidence, by noting there are no provisions for exclusion of evidence based upon the grounds that it was obtained illegally or improperly. This was expressed in Crompton in R versus by Crompton in R versus Latham. It matters not how you get it. If you steal it even, it would be admissible in evidence. It is with great care, then, we should consider how we lynch those in the practice of conduiting information from whistleblowers. It is clear Julian Assange neither accessed nor broke any passwords of the UK government. It has become clear that Chelsea Manning was the source of a great deal of documents published by WikiLeaks, The Guardian, The New York Post and Der Spiegel. It is inconceivable to propose that it was not the source that approached WikiLeaks. It is inconceivable to propose that it was not the source that approached WikiLeaks with a great abundance of information. It is accepted as fact that the most of the information was already in the hands of WikiLeaks prior to the allegations of conspiracy. Prosecution on the basis of text chat is quite simply never going to reach the demands of the criminal standard of beyond reasonable doubt. If this is not self-evident, it only needs to be contemplated how a prosecution could possibly oppose any number of other accounts that would all reasonably fit the same facts. In government guidance, it is explained that in order to access the proportionality of any extradition order, the evidence supplied must be looked at. All major journalist organisations not only subscribe to a code of ethics that protects sources' confidentiality, but in this modern age facilitate their sources' anonymity through secure internet Dropboxes. If a journalist meets a source outside his place of work to transport him to a place of discussion, and he offers him his coat to cover his identity in the event of happening upon a work colleague, or if the same journalist returns him back to work with the understanding that he is to gain more relevant information to developing a public interest story and investigation, is he then a conspirator? The journalist, while his code of protecting his source is righteous and ethical, it is ethical to the profession. It is professional ethics that protects the very notion of investigative journalism, seeking to put valuable information of a public concern in their domain. In the most general sense, the journalist is not the source's friend per se. He is conduit and, where necessary, protector, supporter and teacher. The journalist's role as a teacher In regards of all manner of things, it may be necessary to explain risks, consequences, how events might unfold. It may include educating a source as to which kinds of evidence are the most important to the public interest, which is most relevant journalism. As a valued profession, always seeking to garner more information than a source might have originally thought was in its scope to offer. It is the journalist's job to dig and discover the size and extent of the story that is before him or her. This indictment is a threat and a direct challenge to the freedom of speech and the freedom of expression, since it endeavours to begin the line drawing in respect of who is and isn't a journalist. This line drawing follows all the hallmarks of the no true Scotsman fallacy, in which the wrong-headed individual is oblivious to the arbitrariness in which he selects his criteria to fit the new view, his worldview. The indictment in effect says, the only man safe from political persecution and wrath of power in the event of a source as a matter of conscience disclosing documents of public interest is the singular machine man at the printing press. And there being no guarantees from this point on that last man standing in the process of journalism might not one day draw the ire of authority. This would be unconstitutional in terms of the First Amendment, which aims to protect and ensure the freedom of journalists to disseminate material unless the most clear and present danger standard is met. What the indictment does do is continue the relentless labelling of Julian Assange with unwarranted pejoratives. It is clear the indictment details no hacking, it contains no reference to hacking, and yet most prejudicially its title includes the term, and reliably and as predictably as mainstream media is, most outlets and vendors of news make great truck out of the term, looking for the most sensational way of presenting the story. For all the above reasons, on the evidence presented in the indictment, there does not appear to be a prima facie argument against Julian Assange, as indicated necessary in the consideration of extradition procedures. This guidance explicitly states the quality of evidence should be considered. Insofar as the UK and Swedish governments have acted arbitrarily in their many acts and omissions, it is difficult to imagine any reason for doing so other than due to vested political interests. In regards to the UK, it is often advanced that there is a special relationship between the UK and the US. This arbitrary loyalty, never more so in recent times, being motivational, as Tony Blair would state the UK standing shoulder to shoulder with the US in the so-called War on Terror and the subsequent illegal, unsanctioned invasion of the war upon Iraq. The fact that initial investigations into the Swedish allegations were initially dismissed as having no merit, only to be arbitrarily revived with the help of and intervention of an advocate and political figure, Klaus Borgström, is clearly on its face arbitrary. Klaus Borgström, who was for 7 years the Swedish government's equal opportunities ombudsman, who is reported to have said the likelihood of Assange's prosecution going ahead was only around 50-50. Later he would set up a legal practice with former Social Democrat Minister of Justice Thomas Bodström. Since 2008 he has been Swedish Democratic Party's spokesperson on gender equality. It seems then that Mr. Bodström would have vested interests that lie in the political arena. The very crossing of the line of impartiality between separation of powers that is normally understood to be a vital element of a fairly functioning democracy between the judicial system and executive power seems self-evidently ethically questionable and give rise to conflicts of interest. It is reported that Mr. Bodström's services were dispensed with by one of the women who initially contacted the Swedish authorities after their relationship soured, citing she moved to fire controversial lawyer Claes Bodström after she lost faith in his ability to represent her. She charged that Bodström was more interested in being in the media spotlight than providing her legal counsel. It is also a matter of record that details of Julian Assange's case were very promptly released to the media, contrary to the demands of Swedish constitution, which seeks to protect individuals who are not charged with an offence from such prejudicial and distressing harm. It seems quite plausible to expect this publicity caused Mr. Bodström to solicit his services to this now very public case. Later, even more prejudicial details will be leaked to the Guardian newspaper immediately prior to one of Julian Assange's court hearing. The Guardian writes that the leaked police file found its way to the Guardian's Nick Davis, a reporter whose relationship with Julian Assange has already descended into acrimony. Julian Assange stated he refused to work on the biggest story in a decade, the cable leaks. Nick Davis would later go on to write the unauthorised biography of Julian Assange. The court is not asked to entertain a conspiracy theory, but the court has to acknowledge the Swedish political dimension and the vested interests that have been seen to be prejudicially and arbitrarily take a role in Julian Assange's case. It is to not be, in these circumstances, ignored, as Julian Assange himself reports, that juries in part in Sweden are appointed by political parties. It has been charged by Ecuador that the UK has been obstructive to reaching a political agreement to resolvements in the impasse in Julian Assange's detention in Ecuadorian embassy. In a state of arbitrary detention and legal limbo, Assange's only chance of being provided with a rightful remedy was by a political will to make it available to him. The lack of political will cannot simply be taken as that. Political wills and their absence are in a large part, unfortunately, the court will recognise, driven by vested interests in political capital. The political capital at stake in some measure being clearly visible in the Prime Minister's, Mrs May, announcement to rapturous cheers the arrest of Julian Assange. It is clear it took a UK political will to spend many millions of pounds in stationing officers both inside and outside Ecuadorian embassy and all accompanying surveillance costs. Time only raises the political stakes in the endless need to protect appearances. In the US, the political capital is portraying oneself as a vigorous, uncompromising patriot vilifying and calling for Julian Assange's head has all too readily been seen and given a chilling testimony to in the Julian Assange submission. This has given rise to financial persecution not in accordance with law by Visa, MasterCard, PayPal, Amazon, Swiss Bank, Bank of America, that is commonly understood to have been initiated by political pressures. In House Judiciary Committee hearing, reference to targeted assassination and the US being in a grip of so-called Wikimania is seriously discussed in the context of political will to see Julian Assange prosecuted under the Espionage Act. This political will also being spoken of in the 60 Minutes documentary with Julian Assange. In the same judiciary hearing, Professor Jeffrey Stone, an expert on the US Constitution, gives clear indication that such a prosecution would be unconstitutional, giving and contrasting examples to show that that a clear and present danger standard could not be shown. In the political context, however, it does not seem this would be any guarantee from political persecution leading to a charge with an accompanying protracting isolation and other torturous methods being employed. In the light of recent events already discussed in respect of Trump's presidency, it seems impossible to make a reasoned argument as to how suitable written assurances could be given by the United States. In the light of being labelled by political figures a high-tech terrorist, indeed, if the likelihood of a successful prosecution were deemed to be too slim, there would be absolutely nothing and no power in the world that could prevent the US simply disappearing Julian Assange to that most unconstitutional places and utter heinous crime against the rule of law, Guantanamo detention camp. It would, however, be very easy to politically reason as to the acceptability of any assurances given. Conclusion. The arbitrary detention of Julian Assange has caused irreparable damage and the unrecoverable loss of a portion of his life. Physical and mental health issues are of the UK and Sweden's making. Though this damage garners little sympathy, a Foreign Secretary General glibly states it's not so much Julian Assange being held hostage in the Ecuadorian embassy, it's actually Julian Assange holding the Ecuadorian embassy hostage in a situation that was absolutely intolerable for them.